Case number C-17-141, State of Washington versus Donald J. Trump. Counsel, please make your appearances for the record.
Noah Purcell for the State of Washington, Your Honor.
I'm calling Melody, also for the state.
Welcome.
Good afternoon, Your Honor. Michelle Bennett from the Department of Justice for the defendants, and with me is my colleague also from the Department of Justice, John Tyler.
Thank you. Counsel, welcome. A couple of housekeeping matters to attend to. We are scheduled to conduct this hearing between 2:30 and 4 o'clock. I'm going to have some very brief housekeeping matters at the start, of which I've already used 8 of my 10 allotted minutes. The state will go next. I will tell you that I've given, in effect, 30 minutes to each side. If the state wishes, they can reserve some of their time for rebuttal. They're going first. The federal government's going second. Your prepared remarks, which I'm sure are all very thoughtful and quite helpful, are going to get swallowed by questions, because I have questions that are essential to our resolution of this case, and I need to get those answered. So be prepared for pretty much an interruption from the start. And at around 3:45, having followed the direct presentations and rebuttal, if the state has time left, you're going to hear from the court. It's my intention to orally rule from the bench, but in very conclusory terms, and we will get a written order to follow, so that if you want to have the Ninth Circuit grade my homework, you'll have something that you can get on file there promptly. So that will be the order of the day, and I'm going to hear from the state first, please. Mr. Purcell, let me do one other item. Technically, the motion that's before me started off as a docket 3, which was exclusively the state of Washington, and is now docket 19, which is both the states of Washington and Minnesota. We've also had a series of requests to file amicus briefs, and I intend to grant those. So I'm granting docket 26, the ACLU, docket 42, the Service Employees Union, docket 45, amicus filed by the amicus law professors. Sounds like the three amigos. Let's see, docket 46, I may have mentioned, is the Washington State Labor Council, and finally docket 48, which is the amicus Americans United for Separation of Church and State. Those motions are granted. Please note that it's not a motion for intervention. It's simply authorization to file the amicus brief in this particular question. Mr. Purcell.
Thank you, Your Honor. Good afternoon. In the week since President Trump signed the executive order at issue here, 6 federal judges around the country have enjoined or stayed parts of it in response to actions by particular plaintiffs, finding a likelihood of success on the merits of the challenges. The states of Washington and Minnesota are asking you to do the same here today and to enjoin the parts of the order that we challenge. The order is illegal and is causing serious immediate harms to our states, to our state institutions, and to our people. And enjoining the order is overwhelmingly in the public interest. So you're familiar, of course, with the standard for a temporary restraining order. I won't waste your time. I want to first address the likelihood of success on the merits, including the threshold issues that the government has raised, including standing, deference to national security interests, and the facial versus as-applied nature of the challenge.
Well, let me try and derail you here.
Sure.
I'd like to take this in terms of equal protection first.
Okay.
And in particular, how does the equal protection claim apply to all of the order? This is the 120-day part found in paragraph or section 5A. How does this ban discriminate in any way or violate equal protection when it's an across-the-board ban?
You're talking about as to refugees? Well, Our claim about refugees is primarily that it is religiously motivated discrimination, and that the order is in large part motivated by religious animus. So that doesn't require us to show that everyone harmed by the order is of a particular faith. It just requires us to show that part of the motivation for issuing the order was religious discrimination.
Then I'm going to try and put words in your mouth. Are you telling me then that you're not making an equal protection challenge to the refugee ban?
I would say, Your Honor, that we have I would say the focus there is on the religious discrimination aspect.
And we're going to get to there next.
Okay. And of course, would you like me to address that further, or?
No.
Okay.
Let's move on to my second question on
Okay.
equal protection then. Do refugees or visa holders that have never physically entered the country have equal protection rights under the Constitution?
Your Honor, that is not the focus of our claim. I think the answer is probably no, but they do have rights to some constitutional protections, and certainly their friends and family who are here, and we're just talking about refugees now, not aliens, for example, who might have been sponsored by a university or something like that to come here. Our claim is primarily focused on the people who are here or who have been here and left, their families, their employers, and the institutions here.
All right. Has any court ever set aside an immigration law or regulation on equal protection grounds based on rational review? I understand it's not the centerpiece of your, but you've pled it, so you're going to get questions.
You did plead it, and that's just fine, Your Honor. I was planning to start this morning with due process, or this afternoon, but equal protection is just fine. I am not aware of a immigration order being set aside on on equal protection grounds. On the other hand, I'm not aware of any executive order quite like this one, that there's so much evidence before there's even been any discovery that it was motivated by animus, religiously targeted, and just utterly divorced from the stated purposes of the order. And I'm happy to talk about that more in terms of the government is asking for an extraordinary level of deference here, essentially saying that you can't really look at what were the real motives for the order. You can't test its legality, and we just think that's wrong legally and factually. And if you'll spare me for just a minute, indulge me for just a minute, and let me. There's a legal point and a factual point. The legal point is courts often review executive action that has to do with national security for constitutional violations. If you look at cases like Hamdi, Hamdan, Boumediene, the Supreme Court routinely reviews, those were cases involving enemy combatants being held offshore. Here we have a case that largely involves people who have been here, longtime residents who still live here and have lost rights, and we're asking the court to review that claim. They also suggest, Your Honor, at page 21 to 22 of their brief, based on a case called Kleindienst and Kerry versus Dinn, that you can't sort of look behind the stated purposes of the order. They say that if the president gives a facially legitimate and bona fide reason for excluding an alien, the court will not look behind that reason. But there's two fundamental problems with that argument, Your Honor. First of all, those cases dealt with the president's power to exclude aliens who were not here, had not been here, had no right to come back. That is not this case, where we have a case involving people who have been here, have rights to remain here, and rights to return. And in Justice Kennedy and Alito's concurring opinion in that Kerry versus Dinn case, which is the controlling opinion, they held that they would look behind stated motives, even for exclusion of someone who'd never been here, if the plaintiff plausibly alleged with sufficient particularity an affirmative showing of bad faith. And that's at 2141 of the Dinn opinion. And the Ninth Circuit endorsed that standard in the Cardenas opinion, 826 F. 3rd, 1164.
Well, let me stop, because we're keeping this area then.
Okay.
Do you not see some distinction between election campaign statements and then subsequently an election, and then an executive order which is issued with comment at the time the executive order is issued? It seems to me that it's a bit of a reach to say the president's clearly anti-Muslim or anti-Islam based on what he said in New Hampshire in June.
Well, Your Honor, it might go to the weight to give the evidence, I suppose, but I don't think it's sort of off the table, especially given that we're only a week into, well, 2 weeks now, I suppose, but the order was issued a week after the campaign well, after the president took office.
The inauguration.
After the inauguration, I'm sorry. And so it's not as though those are, completely, irrelevant. And moreover, and again, this is before any discovery, we have the president's advisor saying on national television that the president asked him to come up with a Muslim ban. This was after the election. Asked him to come up with a Muslim ban in a way that would make it legal, and that's what they did. And so
Does the executive order mention the word Islamic or Muslim? Let's stay on religious grounds.
No, it does not, Your Honor. It does not. But when we're arguing about religiously motivated targeting, again, the burden is not to prove that it affects every single person of the Islamic faith. The burden is to prove that a desire to discriminate based on religion was one motivating factor in the adoption of the order. And we're at the pleading stage. 4 days after having filed our complaint, no discovery, and there's already an overwhelming amount of evidence to suggest that that's the case, that it was at least in part motivated by religion. And going back briefly just to the national security, and part of the evidence of that, Your Honor, is that the tie to the stated purposes of national security is so tenuous here. I mean, the president apparently had not decided whether the order applied to lawful permanent residents before it was issued. And there's roughly 500,000 lawful permanent residents from these 7 listed countries in the United States. Either those people are an enormous threat to our safety or they're not, and they've changed their mind about that 5 times since Friday. First they said that it did apply to them, and many of those people were excluded from returning to the country. Then they said, then the Department of Homeland Security reiterated that it applied to them. Then the Secretary said that it didn't. And then this is all in our complaint, by the way. You don't have, and then the White House spokesperson said it did not. And then the White House counsel has now issued authoritative guidance, whatever that means, that although there could have been reasonable confusion about what the order meant, it wasn't meant to cover those people. So the point is, if they were an enormous security risk, you would think that they would have made up their mind about that before issuing the order. The second point, Your Honor.
Well, before we leave that one,
yeah.
What do you say to the argument that the 7 countries that were designated, and I'll quote the language, have been designated as, quote, countries the government of which has repeatedly provided support for acts of international terrorism under 8 U.S.C. 1187. Wouldn't that provide a rational basis for the executive order?
Your Honor, that would provide a cover, in our view, for that was maybe one motivating factor. But when you look at the standard of proving a religious discrimination claim, again, you can't just accept at face value the stated purposes. Excuse me. Especially where, again, before there's even been any discovery, there's so much evidence that it was not targeted at the concerns stated. I mean, the order applies to infants, it applies to senior citizens, it applies to students and faculty at our state universities who've never been accused of any wrongdoing. The bottom line, the main point I guess I'm getting at here is that the idea that you just can't review the real reasons for this order or even ask whether there are real reasons beyond what's stated is just not supported by the case law. And so we're asking you to, the main point is the government's saying you cannot look behind the stated reasons, and we're saying that you can. The case law doesn't support that argument that they're making.
Well, would you agree with me that it is only Section 5 that mentions religion?
It's only Section 5 that mentions religion. We would say it's not only Section 5 that's in part motivated by religion.
Well, and the part of that is this resumption of the refugee program after what I think is 90 days for that provision. And then it says minority practitioners of a minority religion in a country. Does your establishment clause cause of action then extend beyond Section 5?
I think our Establishment Clause claim is focused on that section, but I think both 3 and 5 are motivated in part, our allegation is, by preferring one religious view over another. And that's the Larson case that's cited in our brief makes clear that you don't need to have a distinction between named religions on the face of the order for it to be an Establishment Clause violation. In that case, it didn't name any religions. It just set standards for how different religious groups would qualify for a tax exemption. And the court said that combined with the effects on the religious groups was enough. Your Honor, if I want to spend some time on our due process claim.
Oh, you were going to get there.
Okay, excellent.
Trust me.
And also standing. But if I could turn to the due process claim.
Well, before you go there, let's
Sure.
finish establishment.
Okay.
5B isn't implemented for, I think it's 100 days.
Mm-hmm.
Why should I take this up at this time as opposed to, if you're coming back for a motion for preliminary injunction, deal with it when it's somewhat more concrete?
Well, Your Honor, we're asking you to temporarily restrain what we thought was a narrow subset of the categories that we thought were motivated by these unconstitutional, that violated the Constitution. If you want to have further thought about whether, so we're suggesting that the action itself of banning the refugees and the Syrian refugees indefinitely, and the selection of the countries was partially religiously motivated. If you want to wait and to rule on whether 5B itself and that favoritism approach going forward is a constitutional violation, I suppose that would be fine. That does not necessarily require immediate injunction, but that is evidence. I think that provision is evidence of the religious underpinnings of the order.
All right, once you move on to due process, since I've
Certainly.
used up a fair chunk of your time.
Yeah. So I think the most obvious way in which the order violates the Constitution is its violation of the Due Process Clause. The Due Process Clause protects everyone in this country, including immigrants, and in a number of cases make that clear.
Is it your position that refugees and other aliens who are presently outside the country are covered by due process?
Your Honor, the Supreme Court has said that aliens who are not in the country and have never been here, the only process they're entitled to is what Congress provides. And so we're not, again, they're not the focus of our claim. The focus of our claim is on people who have been here and have overnight lost the right to travel, lost the right to visit their families, lost the right to go perform research, lost the right to go speak at conferences around the world, and also people who had lived here for a long time and happened to be overseas at the time of this order, which came with no warning whatsoever, and suddenly lost the right to return to the United States. And so there's a series of cases, and we cited some of these in our brief, Your Honor, but I'd like to, given that there's only been a short time since the government's filing, I direct you to cases like Landon versus Placencia, 459 U.S. 21.
You want to slow down a little bit.
Sorry. Landon, 459 U.S. 21, Rosenberg, 374 U.S. 449, that make very clear that people who have lived here legally for some period of time and then leave temporarily are protected by the Due Process Clause in attempting to return and cannot have their right to return taken away without some sort of process. And that's effectively what happened here to thousands of people in Washington, including hundreds of students at our state universities and faculty. They just overnight, with no process whatsoever, lost these important rights that they had. Now the federal government...
Missing from your list of cases was Katzenbach, which the government cites extensively for the
Right.
proposition that you've lost that argument.
Right.
How do you respond to that?
Well, they're wrong, Your Honor, for a number of reasons. First of all, so they say we can't cite that case because we're a state. But our claim is not just... Our claim is not the state, as we made clear in our standing brief. Our claim is the state as proprietor and the state as parents patria on behalf of the people of the state. So the state as proprietor, I think, is the most obvious way that argument of theirs is incorrect, Your Honor. We are asserting the due process rights of, on behalf of the people of the state who are harmed and on behalf of the state institutions that they attend. So, for example, the University of Washington and Washington State University, as well as our community colleges, are arms of the state. It's very clear under state law they're arms of the state. We sue on their behalf. And their students and faculty are being denied due process rights pursuant to this order. And if you look at cases like Pierce versus Society of Sisters, 268 U.S. 510, and the cases cited in footnote 3 of our standing brief, it's very clear that schools and universities have standing to bring challenges based on harms to their students. So that's the first way in which we have standing to bring a due process claim. Second, Katzenbach, of course, is before Massachusetts versus EPA and before the significant change in parents patriae standing that case announced, as detailed in the amicus brief of the law professors and as explained in Massachusetts versus EPA itself. So the SNAP decision, the case out of Puerto Rico, cited in our briefing, makes very clear that states can bring parents' patriae claims asserting discrimination sort of causes of action. And then Massachusetts versus EPA makes very clear that the sort of Katzenbach-Mellon limitations on state standing have been dramatically scaled back, if not eliminated altogether.
Well, what's your view of the Fifth Circuit opinion in the United States versus Texas?
Well, it is a strong basis for standing here as well. That was primarily an Administrative Procedure Act claim, and we do have an Administrative Procedure Act claim here. We didn't have space or time to brief it in our temporary restraining order motion. And I should say there's a number of claims actually in our complaint that we think we're likely to prevail on that we just didn't have time or space to brief in the 48 hours and 24 pages of the temporary restraining order motion. Excuse me. And that's one of them, Your Honor. And that case makes very clear that the harms to the state that we're suffering here are sufficient to generate standing in a proprietary capacity. There, the state was arguing essentially added driver's license costs that were sort of unspecified the exact amount. And here, we have claimed very clearly lost tax revenue, harms to our state universities in terms of lost wasted money that was spent sponsoring people to come here to teach and perform research, wasted money that was spent buying tickets for people who will no longer be able to go and speak or research at conferences. A wide range of proprietary harms, Your Honor, that do suffice under U.S. v. Texas to show standing.
Let's go to the INA claim and then leave you some time to actually talk to me. Do states have a right of action under Section 8 U.S.C. 1152A1A?
Your Honor, I'm sorry. I honestly do not have a good answer to that question. I do not. I think we should be allowed to assert the rights of our people here as parents patriae who are harmed by the discrimination, the nationality discrimination embodied in this order. But the INA, I would say our INA claim primarily supplements our other claims by showing that this action, the President's action here, is not endorsed by Congress. It's not consistent with congressional directives. It is actually contrary to what Congress has said about how these sorts of decisions are supposed to be made, which further undermines the federal government's argument for deference to the President's decision-making in this context.
All right, you've got about 10 minutes, and I won't ask you any more questions.
Your Honor, I'm perfectly happy to have you ask me questions. So I guess first of all, I want to overall emphasize that we have two distinct bases for standing here in terms of our proprietary interests, the harms to the University of Washington, Washington State University, our other state colleges and universities, and then our parents patriae claim. Those are real harms in both senses. The federal government really has offered no meaningful response to our claims of proprietary harm to the universities. I know they've claimed that tax harms are insufficient in some of their pleading, but all of the cases they cite predate Massachusetts versus EPA, and they're inconsistent with, for example, the Fifth Circuit's approach in U.S. v. Texas. If the added cost of issuing driver's licenses is sufficient to generate standing, there's no reason why the lost revenue of losing visitors who would come here and spend money should be insufficient to generate standing. More revenue versus less revenue is two sides of the same coin. And as to the universities, the federal government claims that these harms are quote-unquote illusory because most of the people we allege will be affected actually won't be. But there's just no evidence to support that. I mean, so they say now, again, that the position has changed 5 times. And I don't mean any ill intent towards counsel. I know they don't have any control over this. But the federal government's position about what the executive order means has changed repeatedly since the order was issued. And so now they say it protects long-term lawful permanent residents. It doesn't apply to them. But that was not their initial position. And in any event, we have hundreds of students and faculty at our universities who are here on visas who, again, overnight lost the right to travel for any number of purposes or to return to the country. The only other point I'd make, Your Honor, they make much of the idea that this is a facial challenge. We can't show that it's illegal in all applications. And that's incorrect, Your Honor. The Ninth Circuit has repeatedly held that when in analyzing whether something is a facial or as-applied challenge, you look at whether it's a challenge to the entirety of the action or to parts of it. And that's cases like Hoy versus Oakland, 653 F. 3rd, 835. Here we're challenging only parts of the executive order. It's very clear that this is This is an as-applied challenge to parts of the order. We don't need to show that it's unconstitutional in every application. I apologize for citing so many cases, Your Honor, in oral argument. I don't normally do that. It's just that, of course, we had no opportunity to file a response in only a short period of time from when they filed. And the last thing I'd say, Your Honor, for now, and then I'd just like to reserve the remainder of my time, is that the Establishment Clause. The Establishment Clause, one of the original purposes of it was to protect the states against the federal government choosing a national religion and imposing it on the states. So the idea that the state would not have standing to challenge a national government, the president anyway, expressing a preference, is just, it makes no sense. And again, I can't cite you to a case where a state sued the federal government over an Establishment Clause violation, but I also can't cite you to an executive order ever before quite like this one, or the circumstances that we are facing today. So I'd like to reserve the remainder of my time and just conclude by saying the question is likelihood of success, irreparable harm, and the balance of equities. We believe we've shown a strong likelihood of success, as the other courts have ruled, and we'd ask you to enjoin this order temporarily. Thank you, Your Honor.
Bennett, are you arguing?
Yes, Your Honor.
Thank you for coming. I thought your brief was extremely well done. It was helpful.